Hai, Assalamualaikum dan salam satu Malaysia. Welcome back to Let's Talk episode 2 with Jewel tonight. Jadi pada malam ini kita akan membincangkan tentang the system and our very special guest is Dr. Farah Nini Dusuki. She is a senior lecturer in Faculty of Law, Universiti Malaya, and she has been in this field for more than 25 years old. Yeah, more than 25 years lah. Okay. Alright. Jadi, tanpa membuang masa lagi, I'm going to invite her in. Hi, Darren. Thank you for... Hello. Okay. Okay. So, I'm going to invite Dr. Farah Nini into the chat room. Hi, Doctor.
Hi. Assalamualaikum.
How are you tonight?
I'm good, thank you.
Thank you, Doctor, for coming in for our Jewel Let's Talk session episode 2. I know you are a very busy woman. I am so very grateful to have you. We are so honored to have you here with us, Doctor.
It's a pleasure. Pleasure is mine, thank you.
Okay, so without wasting any more time, shall we start? Are you okay with that?
Yes.
Yes, alright. Okay, jadi pada malam ini Dr. Farah akan
Okay.
bercakap tentang the system. Okay, so you know, she will answer some of our questions, and specifically right now, I'm sure all of us want to know, does every child have access to justice? Okay, Doctor. Shall
Okay.
proceed to you. Over to you, Doctor.
Okay. So does every child have access to justice? Victim of child abuse, more specifically, right? Okay, the
Yes.
answer is yes and no. Why
Yes.
yes? Yes, because if they are able, kalau mereka mampu bersuara, mampu berkomunikasi, they are competent enough, yes, the answer will be they may have access. And if they are supported, you see, if they are supported by their next of kin, saudara mara yang tahu, supported by their teachers, supported by the agencies yang menyokong sistem pelindungan kanak-kanak, so the answer is yes, they will have access. Or if their case is identified, kanak-kanak ni kadang-kadang dia tak tahu pun yang apa yang berlaku pada diri dia tu ialah satu bentuk penderaan. They don't even know it is abuse. So sometimes the abuse is identified by the family members or by the teachers or by childcare minders and anyone. Di bawah atas kanak-kanak sekarang, siapa-siapa saja boleh memberi maklumat tentang mensyaki satu kes penderaan kanak-kanak berlaku. Itu yang paling terkini sekali.
Kalau macam gitu public pun dia boleh identify.
Yes. Boleh identify dan boleh buat makluman tu kepada mana-mana pegawai kebajikan masyarakat. Kadang-kadang orang ni bila dia dengar melapor dia ingatkan kena lapor pada polis. Tapi tak semestinya. You can inform to the social welfare officer dekat daerah mana-mana sekalipun. And action insyaAllah will be taken. Okay, so yes, my answer, a child will have access to justice kalau dia able, kalau dia disokong, supported, atau kes dia didera ni is identified, dikenal pasti. Okay, and of course on the other side, the answer will be no if the child is incompetent. Incompetent ni dia kerana dia innate disabilities kan, because kanak-kanak ni ada yang belum mampu berkomunikasi lagi kan, umur dia terlampau muda contohnya, atau dia mempunyai special needs. For children who have special needs, for example, they naturally will not have the competency to even inform of whatever that's happening to them. So because of that, the answer will be no. In that situation, she or he will not be able to have access to justice. The other one, if he or she is unsupported, dia dah beritahu dah, dia dah mengadu dah, tapi sometimes her story or his story is not believed, so nothing gets done. Or sometimes she told tapi she's not supported. She is being said that she's making up stories. And of course, in the third situation, it is unidentified, tak dikenal pasti langsung. Contohnya seorang bayi yang didera, kalau dia tak merengek-rengek, dia sakit pun dia menangis tapi tak ada kesan penderaan, then it is not identified. So kenapa dia unidentified? It is because of the nature of victimization itself. Okay, for child abuse, especially child sexual abuse, dia ada dua musuh utama dia. Okay, shall we see my next slide, Arquila? Okay.
Yes.
Dua musuh utama untuk penderaan kanak-kanak. Number one is silence. Selalunya mereka akan mendiamkan diri. Atau mereka tak tahu pun itu satu bentuk penderaan, so they just remain silent. So silence itself is a barrier to disclosure. The other one is secrecy. Especially kalau the abuse is done by somebody close and whom they trust. The perpetrator will say, this is our little secret, don't tell anybody. You see, so it will remain in secrecy. Ada pernah satu kes tu kan, yang dah sampai ke mahkamah pun, budak-budak ni dibayar oleh pemandu bas Dia
Oh.
didera, yes. In fact, this case, went all the way to the court. Dia didera, lepas tu macam mana dapat tahu? Because budak-budak ni budak tadika. Ayah dia overheard these two girls quarrelling because dia dapat upah seorang tu dapat 20 cents extra daripada the other girl. So they were fighting over the extra 20 cents. So when the father overheard, the father asked, you see, so all this while they were told that it was a secret. You see, and they were paid. And children being children, because they were not hurt. You know, child molestation mungkin tidak mencederakan dia secara fizikal, right? Tapi boleh
true.
mencederakan secara emosi, you know.
Yeah.
Kalau it is not rape, it is just molestation. So possibly dia tak rasa physically sakit, tapi tapi emotionally later dia akan tahu, oh, this is something wrong. So you see, children kan, they are drawn into such secrecy because they are so innocent. So that's the clear barriers to disclosure.
I see.
The other one, okay, let's look at statistics sikit. Jom kita tengok dekat iceberg. Now this is what you call the proverbial iceberg lah dalam case child abuse atau child sexual abuse. Only 1 in 3 cases ever reach, is disclosed, and 1 in 10 cases ever reach the authorities. Macam iceberg kan, you only see the tip, right? But so many other cases dalam bongkah yang lebih besar di bawah di bawah dasar laut itu tersebut. Macam itulah kes-kes penderaan kanak-kanak. Let's look at the other diagram, Arquila.
Yep.
See, this is called the disclosure iceberg. This is very common among us child abuse activists or protectors, okay? Only 20% are cases usually known. Kenapa tak diketahui? Because like I said just now, due to secrecy, sometimes they are told, that they cannot share. You see, they are told that dia tak ada withholding behavior, silence or intentional withholding behaviors. Kanak-kanak jadi withdrawn to themselves. So because of that, cases may not even reach to the attention of anybody. You see, yang 20% yang diketahui ni sama ada dia beritahu, direct verbal disclosure, accurate identification. You see, by selalu kadang-kadang dia mengadu pada cikgu contohnya, atau cikgu perasan budak yang selama ni cergas di sekolah tiba-tiba nampak merosot pelajaran dia. Kan? Lepas tu bila cikgu selidik-selidik, dia tengok budak ni cerita, oh sebenarnya dia sedih sebab apa-apalah yang berlaku kat dia. Bawa pergi ke hospital, confirm it's a rape case. You see?
Okay.
So this happens, it reaches the tip of the iceberg. Okay, so it's the nature of victimization itself yang membuatkan children tak dapat access to justice.
I see. Alright. So based on apa yang Dr. Farah dah terangkan tadi, the access to justice, can the child get access to justice? So it can be both yes and no.
Yes and no. And? Yes, depending on the situations that I have informed you just now lah.
Yeah, alright. Okay, so everybody, all the viewers who just come out, tonight we have Dr. Farah Nini Dusuki, and she is a pensyarah kanan in Fakulti Undang-Undang Universiti Malaya. Okay, so our topic is the access to justice. Alright, so now Doctor, may I ask you, is there any challenges to getting this justice?
Oh, challenges there, yeah? Okay, this will be the challenges for children, for victims of child abuse to gain access to justice. Yes, of course there are challenges. And before we go to the actual challenges, let us try to have an understanding of the function of the law first, okay?
Okay.
Because when we talk about justice, automatically we are talking about the law, isn't it?
Yes.
Let's look at the functions of the law in attaining justice for all. Now, the function of the law is for everybody to get justice. So for the victim, she or he has the right to be protected, but sometimes to protect the victim, we have to punish the perpetrator. Contohnya, kalau yang mendera tu adalah seorang yang rapat dengan kanak-kanak tersebut, orang yang berada dalam satu rumah dengan kanak-kanak tersebut, macam mana kita nak protect kanak-kanak kalau pemangsa tu masih berada di dalam rumah yang sama kan.
Ya,
Itu
betul.
sebab fungsi undang-undang adalah untuk menghukum pemangsa supaya pertama dia tidak boleh repeat ya apa yang dia lakukan kepada mangsa, dan kedua harapannya supaya kalaulah mass media mencanangkan tentang berita ini, ia juga akan menghalang orang lain, prospective perpetrators we call them, daripada menjadi pemangsa kepada kanak-kanak lain juga. So remember ya, functions of the law bukan untuk hukum saja. Orang selalu kata, oh kalau undang-undang ni nak sentence people to jail, nak cane people, you know, it's not just that. The bigger function of the law is to protect. Okay?
Yeah. Okay.
So macam mana kita protect a victim of child abuse? Now, the law has got two types of orders. First, we call it protective orders. Okay, perintah-perintah yang berbentuk perlindungan lah untuk melindungi. So kita bercakap tadi tentang kewajipan untuk memaklumkan kalau kita ada mensyaki kes-kes dera ya. So for example dalam Akta Kanak-Kanak ada 3 golongan yang wajib memaklumkan kalau mereka mensyaki kes-kes penderaan berlaku. So golongan pertama adalah kaum keluarga sendiri. Contohnya bapa tiri melakukan penderaan seksual terhadap kanak-kanak perempuan dalam rumah tersebut. Kalau isterinya tahu, isterinya ada kewajipan untuk memaklumkan di bawah Akta Kanak-Kanak di bawah Seksyen 29. Okay. Golongan yang kedua adalah childcare minders. Penjaga kanak-kanak ni. Kan budak-budak yang ibu bapa dia pergi bekerja dan sebagainya, dia diletakkan bersama dengan childcare minders, pengasuh ya, ataupun dengan di childcare centers. So golongan inilah yang mempunyai tanggungjawab perundangan untuk memaklumkan, katakanlah bayi yang sampai kat dia tu dia tengok ada lebam-lebam. Dia mesti maklumkan. Dia kena maklumkan. In fact kalau dia tak maklumkan, tindakan undang-undang boleh dikenakan terhadapnya. Okay?
Okay doktor, saya ada soalan. Kalau macam itu, maksud doktor childcare minders yang doktor sebut daripada tadi tu bukanlah orang kata orang JKM, bukanlah ya?
Bukan. Childcare minders adalah pengasuh.
Oh, daripada tadi saya ingat JKM. Jadi mungkin
tak. Childcare minders ni dia yang kena maklumkan kepada JKM.
Okay, jadi dia boleh jadi orang awam juga? Ataupun
tapi ini adalah kategori pengasuh ya.
Oh, okey.
Bukan orang awam macam Arquila atau saya.
Okay.
Arquila atau saya masuk dalam golongan yang keempat tadi, anyone, anybody. Orang macam kita pula Arquila. Orang macam kita pula Arquila, kita tak ada macam penalty kalau kita tak memaklumkan. Tapi kalau dua golongan tadi yang saya cakap dan golongan yang ketiga sekarang adalah doktor. Doktor pula tak kira doktor dekat klinik swasta, hospital swasta atau hospital kerajaan atau hospital universiti, semua ada tanggungjawab di bawah undang-undang untuk memaklumkan kalau mereka mensyaki kanak-kanak yang mereka tengah treat ni adalah mangsa dera. So 3 golongan ni, 1, 2, 3 tadi, yang ni diberi mandat khusus di bawah undang-undang untuk melaporkan sebarang kes penderaan kanak-kanak. Dan kategori keempat yang baru dimasukkan pada tahun 2016 adalah orang macam kita, orang awam. Beza dia, kita ni tak ada penalty kalau kita tak buat. Maksudnya if we do it because we are responsible citizens, we care about children, and we are suspicious. Contohnya jiran tetangga kan. Dia dengar, oh kenapa budak ni asyik menangis saja. Selalu menangis. Dia macam tak berhenti-berhenti menangis. So kita punya culture ni tak nak jadi tak nak jadi jaga tepi kain orang kan. Tapi sebenarnya in the best interest of children, tolong jaga tepi kain orang.
Exactly. Okay doktor, soalan daripada Tanam Vanapan. Why are teachers not mandatory reporters?
Okay, why are teachers not mandatory reporters? Well, semasa the fourth category created, it is meant to include teachers, but
Oh.
they do not impose a liability on teacher the way they impose a liability to family members, childcare minders, and also doctors is because it is a form of protection also for doctors. For teachers. You
Oh,
see,
I
because teachers kan
see.
kalau let's say kanak-kanak tahu cikgu ni nanti akan akan bring dia punya case ke let's say lah akan mengadu ke dan sebagainya, mungkin dia tak nak beritahu. So at least there
Hmm.
is one person lah yang selain pada ibu bapa dan sebagainya yang dia boleh trust untuk beritahu to act in his or her best interest. Tapi
Okay.
guru-guru ni memanglah dalam golongan yang 4 tadi yang they are not mandated but they are encouraged to report.
Okay. Okay, doktor. Tadi saya dengar doktor sebut the medical examination doktor
Yes,
klinik swasta.
betul.
Okay,
So sebenarnya sepatutnya sorry?
selalunya macam orang akan nak, selalunya dia orang akan nak report daripada klinik kesihatan ataupun klinik kerajaan.
Sepatutnya tak macam tu. Jangan confuse between medical report dengan report untuk inform tentang penderaan. Medical report memang kena hospital kerajaan punya doctors.
Alright.
Okay? Sebab if you look at my PowerPoint ni kan, dia ada mandatory informing kan.
Yes.
Mandatory informing ni diwajibkan atas kedua-dua doktor private atau private atau public hospital. Tetapi if you look at the third point, medical examination, treatment, hospitalization tu, ini adalah tanggungjawab yang diletakkan ke atas medical officer, pegawai perubatan yang di bawah section 2, mereka adalah pegawai perubatan kerajaan.
Okay, doktor, kita ada soalan lagi untuk slide ni. Shouldn't it be compulsory at least for the teachers to take it up with the medical doctors?
Well, I believe it is in the SOP, the standard operating procedures. When teachers come across cases, they should bring up. But legally speaking, under the Child Act, they are not specifically mentioned. That I have to clarify. But ideally, yes, they should be informing, bring the case to the social welfare officer, or at least bring the case to the doctor so that doctor can examine, and doctor therefore are the mandated reporters.
Okay,
I can see the next question. How about counsellors? Okay. Yeah, is it mandatory to report? At the moment, no, because counsellors, teachers fall under section 29A, whereby anyone can inform the social welfare officer, but if they don't report, no legal repercussion will be imposed on them. Maksudnya, unlike the doctors, childcare minders and family members, there will be repercussions, right? There will be penalties, boleh dikenakan penjara, boleh dikenakan hukuman denda atau kedua-duanya sekali. Tapi yang kategori 29A ni yang termasuk kita semua, dia tak ada legal repercussion kalau tak buat.
Okay, jadi kita boleh sambung doktor dengan slide doktor?
Boleh?
Alright.
So, apart from the protective orders, kita juga ada punitive orders. Punitive orders maksudnya perintah-perintah yang berbentuk menghukum, ya. So, contohnya macam tadi, kalau tak memaklumkan bila mandated under the law, akan ada dia punya penalties, hukuman di bawah undang-undang. Dan juga terdapat pelbagai undang-undang yang membuatkan pelbagai bentuk penderaan kanak-kanak itu sebagai satu kesalahan jenayah. Dan kita tahulah kalau kesalahan jenayah maksudnya the police can interfere, the person can be convicted and there will be legal repercussions.
I see. Okay.
So these are all the sources of the law, ya. Walaupun kita semua lebih familiar dengan Akta Kanak-Kanak, but really they are more than just Child Act to protect children in Malaysia. Okay, Child Act has both features. It is protective, it is punitive. But we also have the Domestic Violence Act 1994. So for example, there is a domestic violence case and the ones that are being abused are not just the spouse but also the children. So kita tak payahlah macam, oh untuk children buka atas kanak-kanak, untuk wife buka Domestic Violence Act, right? So under the Domestic Violence Act, you can get an emergency order tanpa perlu pergi ke mahkamah pun. You can obtain the order to from the social welfare officer again, pegawai pelindung ya, in order to protect the victims. Okay, ini kalau penderaan tu berlaku bukan pada kanak-kanak sahaja tapi juga kepada ahli-ahli yang termasuk di bawah Domestic Violence Act, iaitu suami atau isteri, bekas suami atau bekas isteri, elderly person in the same household and children living in the same household. Okay. The third act which everybody knows very well is the Penal Code, Kanun Kesiksaan. Nama dia pun kanun kesiksaan, kan memang siksa lah. Sebab dalam penal code ni dia ada semua kesalahan almost under the sun, okay? Which includes anything against anybody including children. So dulu kan, sebelum kita ada akta yang keempat tu, yang warna kuning tu kan, so kalau kes-kes penderaan seksual yang teruk-teruk, kita guna kanun kesiksaan. Tapi sejak kita ada akta Sexual Offences Against Children Act 2017 ni kan, kita lebih suka nak guna akta ni sebab dia lebih easier to prove. Dia punya beban pembuktian tu lebih senang untuk dibuktikan, untuk untuk mahkamah dapatkan beban pembuktian tersebut kerana it relaxes a lot of the some rules of evidence which sebelum ni sangatlah mengekang para prosecutors pendakwa raya apabila mereka nak menuduh pemangsa-pemangsa dalam kes penderaan seksual kanak-kanak. So when you look at the Sexual Offences Against Children Act, atau kami selalu panggil akta ni SO Act ya, akta ni boleh dimuat turun di internet ya, because it's not very thick. It is actually about 20 odd pages, so you can download this and be familiar with the different offences under the Sexual Offences Against Children Act. So for example, one offence which I think everybody must know under the SO Act is what is called child grooming, pengantunan kanak-kanak. So contohnya, kalaulah kanak-kanak ni dia berkenalan dengan somebody through the internet. Okay, tak kira lah through Telegram ke, WhatsApp or Facebook, and then the mother found out kan. Dulu sebelum kita ada SO Act, if you bring this to the police cannot do anything because grooming a person sexually is not an offence under the law.
Yeah, and it doesn't even harm them.
Exactly. But under SO Act, anything remotely close to that will be considered as child grooming. And the person, walaupun dia belum lagi sempat nak mendera secara fizikal, secara seksual ya, dia boleh dikenakan tindakan di bawah undang-undang. So that's why it is very important for us advocates of children to be very familiar with Sexual Offences Against Children Act, because apart from child grooming, it also classifies child pornography as an offence with its ramifications. Pelbagai bentuk pornografi, pelbagai bentuk child pornography yang sebelum ni susah kita nak cari bukti ya di bawah penal code, di bawah akta kanak-kanak, tapi di bawah SO Act dia agak longgar ya. So maknanya it is easier to charge a person under the SO Act compared to the Child Act, under child pornography. And the third category will be sexual assault against children, atau dalam bahasa Melayunya dipanggil amang seksual ya. Amang seksual ni boleh berbentuk physical, boleh berbentuk bukan physical. So that's why dipanggil physical sexual assault and non-physical sexual assault. So katakanlah a person has been harassed sexually via orally, itu pun boleh klasifikasikan sebagai satu bentuk jenayah dan pemangsa tersebut boleh dikenakan tindakan undang-undang lah. So before this very hard, isn't it? If kalau tak ada kesan fizikal, pada kanak-kanak tersebut, therefore there is no offence. Tapi sekarang tak lagi ya. Under SO Act ni memang there are more categories ya. And finally there is this act called Evidence of Child Witness Act 2007. Yang ni pun child advocates should know, because when a case is brought to court, you must alert the prosecutor or that these are the measures available under the law which can facilitate the child in testifying. Dia boleh testify behind a shield, dia boleh bagi video tape testimony, provided it is being taped properly by the police, and dia also boleh bagi keterangan dia using a closed circuit television link. I will show a picture of it in my slides later. Okay?
Okay. Saya ada soalan doktor. Tadi doktor mention about sexual harass via orally. So does that mean maksudnya macam orang tu cuma mengatakan bahawa badan awak menggiurkan? Is that what it means?
Yes, because kalau you tengok the different, dia banyak takrifan. Itu sebab saya kata please download this act, Sexual Offences Against Children Act 2017 ni, download, sebab di bawah setiap kategori yang saya cakap tu dia ada dia punya breakdown.
I see.
So dia akan bagi banyak dia punya definitions, takrifan kepada setiap daripada yang saya beritahu tadi lah. Kalau nak ikutkan ada 4 lah kan. Child pornography, child grooming, physical sexual assault and non-physical sexual assault. So di bawah keempat-empat ni dia ada takrifan pula apa yang terangkum kepada setiap kesalahan seksual tersebut.
Okay, so what if yang perpetrator tu pun a children juga?
Oh yes, okay, this is the not too pleasant part lah. Okay, sebab kalau the perpetrator is also a child, he or she can also be charged under this law, tetapi because dia pun seorang kanak-kanak di bawah 18 tahun, the protection for children in conflict with the law should be observed under Akta Kanak-Kanak. Sebab di bawah Akta Kanak-Kanak, dia bukan sahaja melindungi kanak-kanak yang menjadi mangsa ya, dia juga melindungi kanak-kanak yang berkonflik dengan undang-undang. Sebab kita mempercayai bahawa kanak-kanak yang berkonflik dengan undang-undang, selama mana dia belum lagi mencapai usia 18 tahun, dia tertakluk kepada segala bentuk pelindungan di bawah undang-undang supaya mereka pertama tidak akan mendapat stigma daripada sistem jenayah tersebut. Kedua, so that it will not become kesan daripada stigmatization tu kan, dia boleh jadi macam pengulangan semula tau. So we want to prevent all this from taking place. You see, so that's why kita kena for children who come into conflict with the law, we treat them with special measures so that they will not be stigmatized by the system.
I see.
Okay, in fact even better if we divert them all together and not treat them within the criminal justice system as well. That's what is being done overseas lah. Okay.
Jadi saya bagi contoh, macam sebab sekarang ni trending lah kan, remaja kita. Kanak-kanak kan adalah anybody below the age of 18. So remaja kita sometimes they exchange pornography that maybe they got from their own parents. So kalau these parents find out macam, anak saya dah mula tengok pornography, and then she ask, awak dapat daripada siapa? And then anak dia kata, from my friend. Jadi mak dia boleh charge the friend. Is that correct?
That is correct. Tapi of course like I say just now, because dia pun kanak-kanak juga, seboleh-bolehnya kita naklah the system, kita resort kepada not the punitive system tapi restorative justice. Meaning to say that ideally the matter is settled in a more protective way rather than terus deal secara jenayah ya. Sebab bila deal secara jenayah pula, kita ada dia punya repercussions. Because children being children, kadang-kadang benda tu dia tak tahu pun salah. Okay, dia buat sebab seronok-seronok saja kan. Tapi kalau kita terus impose dia, letak dia dalam lockup dan sebagainya, dia akan, the child will be contaminated by the system. So this is what we want to prevent.
Okay. Yeah, alright. Okay. Now
we go to just now we know the kind of offences, right? Sekarang
Yes.
we need to know who are the agencies who are mandated by the law to protect victims. Okay, so generally speaking, there are three main ones. Pertama, the police. Okay, so the police have got special powers under the Child Act to remove victims to places of safety, to arrest the perpetrators. You know, kalau ordinary offences kan, police kena dapat warrant tangkap dulu. You know, banyak kerenah kan. Tapi when the victim is a child, there are special provisions in the Child Act which the police can bypass in the best interest of the child. Okay, so police have got special powers. The other one will be the doctors. The doctors have got, you know, the power to examine, to treat patients and to certify such need in writing. Contohnya, kadang-kala kalau ibu bapa tu merupakan pendera kan, dia akan tak bagi doktor examine. Because through the medical examination, it will confirm, you know, that the child is an abuse victim, right? So according to section 24 of the Child Act, if the doctor certifies in writing that the child is in need of urgent treatment, you know, then the doctor can actually get authorization from the protector, who is a social welfare officer, and bypass parental consent. That is one situation, okay? So that is an example of, you know, kuasa doktor di bawah Akta Kanak-Kanak. And the most wonderful part about Akta Kanak-Kanak ni, it doesn't just mandate you with special powers, it also supports you. For example, if you conduct a medical treatment in good faith and an unfortunate consequence take place, maksudnya katakanlah the treatment result in something not so pleasant, ya. According to section 26 of the Child Act 2001, there will be no liability imposed unless the doctor was negligent lah. Kalau doktor tu cuai, contoh-contoh cases medical negligence yang biasa, yang tu walaupun you ada parental consent pun you akan dikenakan tindakan di bawah undang-undang kan kerana cuai. So tapi kalau you buat case you discharge your duty in good faith, then you will be protected under section 26. And of course, finally, the third agency yang sangat-sangat berkuasa in child protection will be the JKM officers atau the social welfare officers. Okay, tapi kita on the ground selalu panggil JKM officers, right? So JKM officers have got extensive powers under the Child Act. They have got the power of removal, they have got the power of investigation, they have got the power of authorization, you know, bila doktor perlu bypass parental consent, they have got power to authorize that treatment among others. Tapi kita kena faham, social workers ni, social welfare officer ni, dia are not just pelindung di bawah Akta Kanak-Kanak. Mereka lah juga pegawai akhlak di bawah akta yang sama. Mereka lah juga pegawai pelindung di bawah Akta Keganasan Rumah Tangga. Mereka lah juga the social welfare officer di bawah mental health, for example. Di bawah akta apa-apa pun, they are the same officer. So imagine if in a small district, you have one social welfare officer, so he or she is wearing the different hats, taking care from the womb till the tomb. I am not making excuses. Bila saya cakap macam ni kan, ada orang kata Dr. Farah ni nak protect children tapi making excuses, you know. I'm not making excuses, but I am actually telling what is happening as a fact. So what we should do is that we should increase our social welfare officers, we should increase our resources, we should give more trainings to, you know, to all of our agencies ni yang mempunyai segala kuasa di bawah Akta Kanak-Kanak, the police, the doctors, the social workers, because it is not because the law does not protect children and therefore children does not get access to justice. Tapi masalahnya kita yang dewasa ni yang gagal untuk melindungi kanak-kanak yang memerlukan kita. Okay? I see the question. Is it mandatory for a doctor to make a police report if he suspects a sexual abuse? Well, the law says it is mandatory for him to inform the social welfare officer, but there's nothing to stop the doctor from also making a police report.
I see. Okay, doktor, saya cuma nak tanya, macam at the moment we have these three agencies, police, doktor and social workers. How about NGO? Doktor rasa macam bila agaknya NGO boleh be
Okay,
one of the intervention?
boleh. Sekarang one of the positive changes in the Child Act is the appointment of assistant child protectors. Assistant protectors for children. So assistant protectors ni lah yang can include NGO.
I see.
But of course you need to be, I believe you need to be recognised by the JKM for, let's say, in a particular district to be the assistant protector for that particular district. So contohnya, you know, we have our friend Syed Azmi who is also an assistant child protector dekat Petaling, for example. Okay. And that is how it should also happen in Johor, you know, for activists like macam Arquila and Jewel, get yourself recognized by JKM so that you can also assist in the intervention works. Alright. Dalam langkah-langkah intervensi untuk membantu kanak-kanak ni, you can assist the JKM officers.
Okay, so kalau macam gitu tadi, assistant child protectors, dia orang ada jurisdiction by area lah. Contohnya macam tadi, Syed Azmi, dia Petaling Jaya. Jadi dia cuma boleh lindungi area Petaling Jaya.
Petaling is quite wide. Yes.
So maksudnya macam dia tak boleh intervene untuk orang kat luar.
It is quite territorial lah. It is quite territorial because that is the reason why they are called assistant child protector for that particular place kan. Sebab tugas dia adalah untuk memberi sokongan kepada protector yang seperti saya katakan tadi mempunyai tanggungjawab yang terlalu banyak di bawah undang-undang yang pelbagai. So kita adakan assistant child protector ni supaya they can support the protector in discharging their duties.
Alright, okay. Alright, okay, next.
So remember I said just now, kadang-kala in certain types of abuse, it is so serious that the only way for us to protect the child is to remove the perpetrator. Seboleh-bolehnya kita tak maulah pisahkan ahli keluarga dengan mangsa sebab kadang-kala mereka mempunyai hubungan keluarga yang rapat. You see, maybe it is a case of physical discipline that went wrong. So that is why the importance of the protector investigating the case thoroughly to identify whether it is a serious abuse or it is a one-off situation which can be rectified. Sebab I believe that the family, and it is also the concept under the Akta Kanak-Kanak, that family-based care is still the best. You know, kita nak kekalkan unit keluarga ini seboleh-boleh mungkin daripada kita take away the child, letak kat institusi dan sebagainya. Kita kalau boleh kita nak family tu kekal. Tapi unfortunately sometimes the abuse is so bad. So when the abuse is so bad, the only way we can protect the child is to take action against the perpetrator. But like I say, it is not the best option in protecting the child. Sebab the child has got other interests as well, isn't it? Because you know why? If you go to my, if you look at my next slide, I will tell you why dealing with the case via the criminal justice is not in the best interest of the child. Okay, this is a statistic in England and Wales, Nampak tak? Kalau you look at the statistics kan, case yang sampai and this is not satu statistik yang janggal. This is representative of most jurisdiction in the world. Between 2012 hingga 2014, estimated cases hampir 500,000. But if you were to look at this, yang masuk ke sistem makin berkurangan. Nampak tak? Yang reported to police after investigation by the social services even lesser. Yang bila polis dah investigate, yang mana classify as no further action, makin berkurangan. Confirmed cases of child abuse lagi kurang, and convicted kan is less than berapa? About 5,000 sahaja. So why is this? The reason for this is because for criminal cases the burden of proof is very high. It is beyond reasonable doubt. Maksudnya kalaulah kesalahan itu tidak dapat dibuktikan melangkaui keraguan yang munasabah, orang itu akan dilepaskan bebas begitu saja. Sebab undang-undang jenayah ni dia bukan macam undang-undang sivil. Undang-undang sivil yang saman menyaman ni, oh mungkin kita minta 1 juta, kita dapat 100,000 sahaja. Tapi criminal law ni, you are either as guilty as can be or as innocent as can be under the law. So walaupun it's a great frustration when kita on the ground ni tahu, oh memang this case banyak bukti, tapi malangnya bila sampai ke mahkamah, bukti tu tak cukup, and because bukti tak cukup, dia tak lepas that burden of proof tu, so the person has to be acquitted and discharged. And in cases of child abuse, this is terrible because the discharged person can go back to very same house where the victim is. Isn't it? So we have to understand why is that the conviction rate is actually quite low. So I guess this will be my next slide lah. Okay. So if you look at the legal challenges ada banyak. Kadang-kala kelewatan dalam mendapatkan rawatan perubatan, delay in getting medical treatment. So in cases of rape, for example, when the victim has already cleaned herself thoroughly, she has would have gotten rid of all possible DNA evidence.
True.
Okay. True. Of course kalau dia seorang yang lebih remaja contohnya, dia boleh still testify and that will still be acceptable by the court. Tapi what if the child, seperti saya kata tadi kan, dia tak ada linguistic ability, tak boleh nak berkomunikasi. So there will be no physical evidence available. Okay. Another possible situation is the poor documentation of medical investigation. Maksudnya katakanlah labeling of the swab tu tak jelas atau tersilap, atau daripada tangan doktor kepada orang yang hantar ke lab contohnya, tak dapat dikenal pasti. So in that situation, the chain of evidence which is required in the criminal justice system will be broken.
Oh, so dekat situ pun dia boleh cari.
Yes. So kita nampak benda tu kecil, right? Tapi in criminal trial, the chain of evidence tu mesti as complete as we can possibly afford to be. Memanglah ada kadang-kala kesilapan here and there. Tapi kalau hakim merasakan bahawa kesilapan itu tidaklah sampai menjejaskan keterangan kes tersebut kan, then it's okay. Tapi kadang-kala it will affect the identity of the specimen, for example. In that situation tak boleh. Because dalam undang-undang jenayah ni, dia ada satu prinsip yang berbunyi, it is better to release 10 guilty persons than to convict 1 innocent man. Of course, in other cases, that is more acceptable. Tapi kalau case child abuse, saya rasa it's very hard to accept, isn't it? Because for us, one perpetrator is one perpetrator too many.
Yeah.
Because it's always one child at a time. We have to focus on one child at a time. So if that's why our system must support the child regardless if the perpetrator is charged or is convicted or is acquitted. Tugas kita, perlindungan kanak-kanak tu mesti tetap kita laksanakan. Another situation will be general lack of support for vulnerable victims, witnesses. Kan? In my next slide, I will show you, but not yet. I will show you gambar mahkamah, special court for sexual offences against children. Tapi malangnya mahkamah tu tak ada di seluruh tanah air kita. At the moment, to the best of my knowledge, hanya ada satu di Putrajaya, satu di Kota Kinabalu dan satu di Kuching. So that facility yang canggih ni belum lagi ada di negeri-negeri lain. So that will also pose a challenge for the vulnerable witness to testify in court. Another challenge yang ada dalam undang-undang adalah kadang-kala peruntukan undang-undang tu sendiri yang tak support children. Contohnya di bawah atas keterangan, kalaulah kanak-kanak itu memberi keterangan di mahkamah, mesti ada keterangan sokongan, corroborative evidence. Okay? Now, child abuse often happens in isolation. So where can you get corroborative evidence, isn't it?
Yeah.
If a child tells her mother and the mother goes to court informing the court that, oh, my daughter has been molested, she told me this. Itu adalah keterangan dengar cakap, hearsay evidence, which technically is unacceptable in court. Tapi fortunately for sexual offences, di bawah Akta Kesalahan Seksual Terhadap Kanak-kanak 2017, so Act tadi, this requirement has been relaxed. Maksudnya there is no more requirement for corroborative evidence where the victim is a child and where the abuse is sexual in nature. But sadly, it does not extend to, for example, physical abuse. It does not extend to emotional abuse. It is only restricted to sexual abuse according to the law. Okay, the other reason is, I've spoken about general lack of competency of vulnerable witnesses. The other one, professional witnesses, general inability or difficulties in becoming effective witnesses. Ini kadang-kala berlaku apabila contohnya, katakanlah Arquila tak pernah pergi ke mahkamah, right? Tapi you were the one who handled the child. And sometimes bila kena belit sikit soalan dengan defense counsel, you dah orang panggil gabra kan, or you become nervous and then you accidentally say something that you didn't mean to. Because kan defense counsel suka tanya, is it possible? Memanglah it's possible, but it's highly unlikely, you see. So kalau a witness tu is an experienced witness, he or she, let's say a doctor who is so used to going to court, he or she will know that, that is the trick of the defense counsel. So he or she will be firm in asserting what he or she believes. But sometimes you have a very young doctor who has never been to court, and then the defense counsel try to manipulate, because the defense counsel, they try to shake the evidence. Okay, because untuk dia cuma perlu raise a reasonable doubt saja, remember?
Yeah. Sebab
beban pembuktian tu mesti melangkaui keraguan yang menasabah kan. So kalau dia boleh menimbulkan keraguan yang menasabah, so dia punya klien, pemangsa tersebut mungkin bebas. So you see this is one of the many challenges. The other one is the general, I say general, okay, I'm not saying all. I know there are more professionals who are trained, who are sensitive to children compared to 25 years ago when I started in this field. Tapi there are still professionals who are not quite sensitive to the special needs of children. For example, bila tanya soalan dengan kanak-kanak, tanya seolah-olah tanya orang dewasa. Cara dia menanya tu macam dia tanya orang dewasa. So kadang-kadang kanak-kanak ni, when you ask in court for example, betul tak kejadian tu berlaku pada 12 Julai 2014 contohnya. Kanak-kanak ni, dia takkan remember kan? Abstract facts like exact details of dates. Tapi for example, if the prosecutor is an experienced one, dia akan relate. Isn't it that day when you had your sports day, that was the day when you came back and you were hurt or something like that. So you see, there are ways that you can actually ask the child to get the truth out in court without undermining, tanpa melemahkan keterangan yang cuba diberikan.
I see.
Okay? So these are some of the example lah, general lack of sensitivity or general lack of expertise tu dua perkara yang lebih kurang sama lah. So if you look at my next slide, that is the picture of the special court. Okay, the special court in Putrajaya. Now this special court was established in June 2017. It is called the Special Court for Sexual Offences Against Children, and you will see, if you look at the picture kan, nampak tak hakim tu ada kat situ, tak ada kanak-kanak pun dalam mahkamah tu. Sebab kanak-kanak berada dalam bilik saksi 2 floors away from the courtroom. So that child will be in this very nice witness room, nicely done up with IKEA punya furniture, toys and everything. And there will be a small microphone on the table. So when she talks to whoever who is questioning dekat big screen depan dia, she is comfortable or he is comfortable. You see, dia tak adalah rasa macam takut dia bila berada dalam mahkamah yang in front of you tu kan. Mahkamah tu kita yang adult pun kadang-kadang seram kan bila masuk in a place which is, everybody pakai coat hitam, jubah hitam, you see, and everybody looks so serious and very adult. So in that witness room, the child can testify and the officers in the courtroom can actually see the child, can hear and listen to the child clearly via the computer, the screen in front of them, and justice will not be compromised. Okay?
Okay, Doktor, saya nak tanya tentang court ni.
Okay.
for all children. Maksudnya macam tadi saya cakap lah, children is everyone who is under the age of 18.
Yes,
Adakah
it's
untuk
to all.
itu ataupun macam untuk yang dah remaja yang boleh bercakap sendiri, then dia orang face the you know the
Okay.
professor.
Asalkan kanak-kanak itu mangsa kesalahan seksual, dia berhak untuk mendapatkan hak untuk didengar kes tersebut di mahkamah khas ini. Okay?
Jadi macam kalau yang form 3, form 4, form 5 pun they don't
Boleh.
dia akan yalah dia tak perlu berhadapan dengan orang yang
Yes.
salah aku tu lah.
Yes.
Okay.
So why is it that we want to protect children so much? You know, kenapa kita semua ni sangat concern sangat we are very serious about protecting children from any potential abuse, be it neglect, physical, emotional or sexual. It is because the impact of child abuse is impact of a lifetime.
Yes.
Can you show the next slide, Arquila? Okay, this is a scientific evidence which goes to show the brain. This is the MRI image of a healthy 3-year-old compared to a 3-year-old who has been subjected to extreme abuse. So if you look at the left hand side, that is the image of the brain of a 3-year-old yang sihat. Okay, and if you look at the size pun, the one yang subjected to extreme neglect, dia punya brain is a lot smaller than a normal 3-year-old child. So you see, and the impact will be for a lifetime because there will be health risk behaviours. Dia lebih terdedah kepada sexual promiscuity. Dia lebih terdedah kepada sexual violence, alcohol abuse. Ni semua proven by studies to drug use, smoking, behavior problems. Not just health risk behaviours, that child who have been abused will also be more prone towards disease and injuries. You know, later in life, stroke, diabetes, cancer, you know, suicidal attempts. And of course, siapa-siapa yang menjadi mangsa penderaan yang tidak dibantu chances are akan menghadapi masalah mental dan masalah sosial. Mungkin boleh mendapat post-stress traumatic disorder and then boleh mendapat depression, kemurungan, anxiety, eating disorders, bulimia, anemia dan sebagainya, cognitive development delay, unwanted pregnancies, obesity, just to mention a few. Okay, so hopefully if we protect our children better, then our children will look like the next slide. You know, they are happier children, and we will have, you know, children with, you know, who have all the right to childhood as they rightly deserve.
Yeah, thank you Dr. Farah. Okay, this is actually hello viewers. For your information, Dr. Sarah punya slide dah habis and this is actually our question and answer punya time. So if you have any question that you want to ask Dr. Farah, please do so. Okay, let her post your questions and then she will try to answer as many as she can.
Okay. How do we educate children to report abuse and to do it before the evidence are gone? Okay, this is where child empowerment comes in. You know, children must be told that abuse is wrong. They must be taught on safe and unsafe touches right from, you know, tak boleh tunggu bila masuk sekolah. You know, people always say about, we must introduce sex education in school. Well, I always tell parents that if you wait for teachers to talk about it, it's already too late. You know, you must actually teach sexuality education to very young children, because if you don't do that, they will learn it elsewhere.
True.
And they must be taught that, you know, that certain touches can only be done by certain people. So if it's done by, you know, by others who are not supposed to, then you should tell the next trusted adult. Tak kira lah whether it's your mom, it's your dad, it's your teacher, but they must be empowered to do so. Thank you Adlan Rahman for the question.
Okay.
Okay,
What
to be assistant
child protector?
Okay, what are the qualifications? I believe it must be somebody within the district who is familiar, who has done work with children for the person to be qualified, because that will be the criteria that you have the best interest of children at heart. But of course, this will be subjected to to JKM's reception to your permohonan, ya.
Yeah. Okay. Okay, so actually Dr. Farah, for your information, last week we have a talk about victim and how
Okay.
to handle victim blaming. Okay, but maybe we didn't cover the topic enough, and because we still have time, do you mind covering it with me?
Oh, of course I don't.
Okay. Okay. So just like a recap of last week punya topic. Who is called a victim. So yang ini a very general who is called a victim. A victim is a person who has been hurt or taken advantage of. Tapi from the perspective of lawyer, siapakah mangsa Dr. Farah?
Okay, from the perspective of a lawyer ni pun ada dua, Arquila. Lawyer tu kalau dalam undang-undang jenayah, lawyer dalam mahkamah ada 3 bentuk lawyer. Hakim pun is a trained lawyer sebenarnya, right? And then you ada prosecutor, pendakwa raya, who will be prosecuting on behalf of the child, and you have the defense counsel who will be defending the perpetrator.
Oh, so does it mean that they all have a different vocab of who is a victim?
Yes, because if, for example, if I am a defense counsel and I believe in my client's innocence, okay? So for me, my client is a victim of situation. You see, but of course, I'm sure in our discussion we are talking about victim of abuse, right? So definitely, the victim of abuse is somebody whose right has been transgressed under the law. And whether you know or you don't know whether dia punya right has been transgressed, itu sebab kita ada takrifan di bawah undang-undang bagi pelbagai kesalahan jenayah. Isn't it? I mean, I spoken just now, right? Sexual assault can be physical, can be non-physical. So if you breach that, if what you have done amount to either one of those categories, then obviously you are actually a perpetrator and there is a victim.
I see. So tapi macam tadi Dr. Farah jugalah, because we have the burden of proof, jadi the defense counsel boleh manipulate and make their client as the victim instead of the real victim. Correct.
Okay, to be fair, he or she may not want to manipulate, because the duties of both sides of the lawyers is to get justice, right?
Yes.
Okay, so in order to get justice to him is to lepaskan dia punya client, right?
Client.
So bila dia nak lepaskan klien dia punya tanggungjawab utama is to raise reasonable doubt, like I say, right? So dia kena cubalah sedaya upaya untuk shake the prosecution punya case, because dalam undang-undang jenayah kan, dalam perbicaraan jenayah, pihak pendakwa raya yang mesti membuktikan kesalahan tertuduh melampaui keraguan yang munasabah. You see? So prosecution must do his or her very best. Itu sebab tadi kalau you remember my earlier chat kan, where when I showed you why the rate of convictions is very small, tengah-tengah tu ada no further action kan. This is where bila prosecutor dia study the file, okay? Dia study file, okay, allegation is abuse has taken place. Tapi bila dia tengok bukti tak cukup, so kadang-kadang dia tak bawa pun kes tu ke mahkamah, sebab dia tahu for sure kalau dia bawa kes tu ke mahkamah, kes tu tak boleh bertahan pun. I give you an example, an obvious case of child abuse which hardly ever reach the court unless you ada CCTV. That is shaken baby syndrome. You know, goncangan syndrome, goncangan bayi tu. Kan ada kes-kes di mana it is a form of child abuse whereby a child suffers brain injury kerana digoncang dengan kuat. Okay, that's actually child abuse, and there is a term for it. It's called shaken baby syndrome. Now, in cases of shaken baby syndrome, it's very, very hard to bring to court because number one, it happens to a baby yang tak boleh nak bercakap, betul? If the circumstantial evidence is so strong, for example, bayi tu berlaku macam pembuihan mulut dia keluar froth, okay, from the mouth immediately after you ambil daripada pengasuh tu. Okay. So maksudnya dalam rumah tu ada pengasuh tu seorang saja. So the high propensity of tak ada orang lain yang buat is there. So in that case, mungkin kes tu akan dibawa ke mahkamah. Atau ada rakaman CCTV. This one selalunya pemangsa tu akan mengaku salah lah. Jadi dibawa ke court, you charge dia cepat mengaku salah. Because dia kata, how can he hide kan? There is this CCTV recording of him actually doing it kan. So in that situation, dia akan mengaku salah. Okay.
Okay, so under Protection Act yang tadi Dr. Farah dah terangkan, kita ada SO Act, Child Act, Penal Code. Okay, soalan daripada Durga Devi, does this protection includes refugee children?
Yes, definitely, because none of the acts which I've mentioned earlier, be it Child Act, be it Sexual Offences Against Children Act, Evidence of Child Witness Act, and the list goes on, none of it defines children as someone below 18 who is a Malaysian. The definition under Section 2 of a child of the Child Act is anyone below the age of 18 years old shall be classified as a child under this act. Dia tak mention pun status kewarganegaraan, dia tak ada sebut pun tentang taraf kewarganegaraan dia. So it applies to anybody. But the challenge is siapa yang akan bawa kes tu ke pengadilan. This is where advocates come in.
Ya, betul. Sebab refugee.
Okay, I can read the question here. Are there any updates or revisions to the current criminal justice system to improve children's access to justice, or do you think the current system is actually sufficient? Okay, when you talk about updates and revisions, I think I have just mentioned about the amendments to the Child Act just now. There have been major amendments made in 2016 and enforced in 2017, and also the Sexual Offences Against Children Act, which have relaxed the difficulties which used to be faced by child witnesses. Okay, so in terms of the law, I would say it is fairly, I'm not saying it's perfect, I'm saying it is fairly adequate, but the law cannot exist on its own. You see, it is up to the stakeholders and the players of the justice system to make the law effective. So for example, we have mandatory informing, I mentioned just now, right? But if people do not inform and they get away with it, no action taken against them. So others will just say, alamak, tak payahlah buat. Kalau tak buat pun, bukan ada apa-apa tindakan. You see or not? So that's why even though we have very good laws, we need to implement it well. We need to enforce it strictly. Otherwise, the system will fail, not because the legal framework is inadequate, but because we adults who are responsible are not discharging our duties towards children adequately.
Okay, we have next question.
If there are not enough evidence to convict, can the custody of the child still be taken away to protect the child? Wow, this is not an easy question. But yes, strictly speaking, legally speaking, the answer is yes, because under the Child Act, I mentioned about protective orders. So you don't need to have a conviction in order to take away a child from the parents or the legal guardian. For example, if the protector feels that the parent is unfit, if the child falls under any of the categories under Section 17, which classifies children to be in need of protection and care, an application can be made to the Court for Children to take away the child. and to, for example, place the child into the next fit person who can be another relative, or to place the child with a foster parent, for example. These are not, of course, the best options for the child, but like I say, sometimes you have no choice. But if the perpetrator is in the same house as the child, you either need to remove the perpetrator, or if you can't remove the perpetrator, then you've got to save the child. So I hope that answers your question, Mr. Adlan Rahman.
Okay, thank you, Doctor. You have a very nice presentation, and it's a very great talk to be sharing this with you. Any more questions, viewers? Do you guys have any more questions? Dr. Farah is still here to answer some of the questions if you guys still have. Okey, Doktor. Sementara kita nak tunggu, mungkin viewer tengah fikir nak tanya soalan apa, saya tanya soalan lagi.
Okay.
Okey.
Yes,
Okey,
Arquila.
bagaimana pula dengan kes suka sama suka?
Okay, kes suka sama suka ya. Kalau overseas dia panggil the Romeo and Juliet law. Now in our country dia tak ada apa orang panggil, dia tak ada pemisahan secara perundangan ya terhadap kes suka sama suka atau kes tak suka dan kena dera. Okay, I'm sure what you are referring to, Arquila, is when a child is below, the girl is below 16 years old, and what if dia ada hubungan seksual dengan boyfriend dia yang also berusia 16 years old. Now, legally speaking, under the law, the boyfriend can be charged under apa? Under, tak kisahlah if the offence is under the penal code, bawah rape for example, di bawah penal code lah. Kalau di bawah SO Act, di bawah SO Act lah. Tapi this is where the prosecutor will exercise his or her discretion. Okay, whereby if the prosecution thinks that it is not in the best interest of the case to proceed via the criminal justice system, then a different measure will be taken. But masalahnya sekarang selalunya kalau dengan kanak-kanak yang saya jumpa lah di sekolah tunas bakti, di sekolah Henry Geni atau di penjara, dek kerana apa yang dipanggil statutory rape ini ya, yang mana kes suka sama suka, usually the case is when keluarga pihak perempuan, or for one of a better word, mangsa in that case, okay, the female party insist on taking criminal action. So dia tak kisah, you know, walaupun anak dia sayang sangat pada boyfriend dia pun, tapi pada dia pasangan you know, the boy has actually intruded in the girl punya life, and therefore tindakan undang-undang mestilah diambil kan. So that will be the unfortunate situation whereby tindakan undang-undang akan diambil terhadap kanak-kanak lelaki tu jugalah. Tapi I'm happy to say that when I did this study on statutory rape at that time lah, between 2011 2013, for some reason during that 2 years di penjara tak ada kes yang macam tu. Di penjara tak ada kes di mana magistrates atau hakim are more likely to hantar kanak-kanak tersebut to Henry Geni ataupun to sekolah tunas bakti, bergantung kepada usia lah. Kalau dia bawah 14 tahun, dia tak boleh hantar ke Henry Geni sebab Henry Geni mesti 14 tahun dan ke atas. So dihantar dekat sekolah tunas bakti. Tapi I strongly feel that in kes suka sama suka, that will not be the best option, and this is where we hope one day we have what is called restorative justice keadilan secara restoratif, di mana we treat the case where, you know, both are children in a more restorative manner, meaning to say instead of subjecting the child perpetrator to punitive punya action, tapi we treat him in a more protective way in order to rehabilitate the child, so to speak.
Okay, thank you for answering that. Okay, jadi Dr. Farah, last but not least, what is your takeaways to our audience?
Okay, takeaway is that one child, my often quoted line when I do my training is that one child at a time. You know, focus on that one child, because as as practitioners, as child advocates, especially NGOs, I'm sure sometimes you feel so overwhelmed with so many cases. You see, but to you and to practitioners also, that is one of your many cases. But to that child, it is his life, you know, it is his future. So that is why you must treat one child at a time, because when you save a child, you will save the future.
Okay, Dr. Farah, kita suddenly ada satu lagi last question of the night.
Do you think children should be exposed on their rights in the school? Definitely. I know some there are some actions being taken by activities conducted by Suhakam, for example, to have programs in schools on empowering children on their rights. You know, but like I say, don't have to wait for the school to actually have this program. Start it at home. You know, when you respect your children, you are actually empowering the child, because a child have got 4 basic rights. Number 1, the right to survival. Number 2, the right to protection. Number 3, the right to development. And finally, the right to participation. And the 4th right is the right that we parents or we adults always forget. You know, when we investigate a case also, we ask everybody but the child. Always listen to the child. Chances are, when you listen to children, you will learn a lot from them. Trust me, I know. I learned a lot from my 6 children.
I also learned a lot from my 3 children. Okay, Dr. Farah, thank you so much for your time. We are very honored to have you. And maybe next time kita ada lagi talk, boleh invite Dr. Farah lagi.
InsyaAllah.
Okay. Okay, so that concludes our evening.
Okay.
Okay, thank you for being
Assalamualaikum.
here. Yeah, Waalaikumsalam. Alright, okay. Okay, to all our viewers, before I end our live talk tonight, I just want to tell you, sekiranya anda mempunyai kanak-kanak ataupun mengenali kanak-kanak ataupun remaja yang hamil, okay, anak luar nikah mungkin disebabkan oleh suka sama suka ataupun kanak-kanak orang kata child abuse lah. Okay, anda boleh salin nombor telefon ini, Matron Hashimah 012-782-0771. Okay, Matron Hashimah dia menjaga generasi kusayang, di mana generasi kusayang merupakan rumah perlindungan bagi remaja hamil. Dan kita ada JKS ini di Johor dan juga yang terbaru di Terengganu. Yeah, if I'm not mistaken lah. Tapi you guys can Google and hopefully kita ambil iktibar daripada talk Dr. Farah tadi. Let's restore and let's protect. Okay, if possible, kita try to avoid punitive action, avoid the punishment. We try to protect the children and we try to restore their behavior. Because as what Dr. Farah has said, setiap tindakan kanak-kanak itu adalah kesan daripada, you know, maybe environment or maybe he or she was once a victim, you know, they will never learn this all by themselves. It must have been some other things and some groomings, we never know. Okay, so let's all try to save one child at a time. Okay, dan satu lagi, Pertubuhan Pergerakan Wanita Johor really needs your support. Jadi kepada sesiapa yang mungkin you want to donate to our projects, okay, kebanyakan projek kita adalah kita membantu kanak-kanak untuk sambung belajar, di mana kes di luar daerah macam perkampungan orang asli, sometimes we get a case, a call yang mengatakan bahawa anak dia dapat sambungan untuk masuk asrama penuh ataupun universiti but doesn't have the money to pay, and usually kita bantu mereka lah. Okay, kita bantu mereka untuk pergi ke sekolah. Kemudian kita juga membantu kes terbaru adalah dia orang Malaysian tapi dia tak ada IC, dia tak ada birth certificate. Okay, so we also need money to do the DNA testing to get back her certificate and get her back on track of her life. Okay, jadi kita memang banyak ada project, and because of this MCO, our funds are also running low. So hopefully we can get you to help and to donate to us. Okay, CIMB Bank, 8601567402. Okay, Pertubuhan Pergerakan Wanita Johor Projects. With that, I am Arquila Kamarudin. Thank you and good night. Okay.